first, I'll speak to you about what's called, and this is, I know this is, I hope this doesn't make your eyes glaze over, but if I haven't already, but justiciability, which I know is a mouthful, but it includes a doctrine that you may have heard before called standing. So when someone comes into court, they have to demonstrate that they've experienced an injury. They have to demonstrate that their injury is fairly traceable to the defendant's conduct, so that it was caused by the government official they're in fact suing, and they have to show that if they got the remedy they're seeking, that it might actually help them in some way. I mean, right? That is, ameliorate their injury or make their injury less impactful. Now, at a high level, this all makes a certain amount of sense. This is a doctrine that was constructed mostly in the 1930s and was refined over the decades that followed. But there are some ways in which it can really deeply obstruct, in some instances, the ability of people to enforce their rights. So one setting where we see this is that the court said in the early 1980s that when someone is seeking a federal injunction, they not only have to demonstrate that they've experienced an injury at some point in the past, they have to also demonstrate that they are likely to experience that same injury at some point again in the future, right? So that is, in the example I gave of if someone, if right now, if someone came in and said, oh, I didn't know you were talking about the government, and hauled me out of here, right? I might be able to sue for damages, perhaps, although we'll get to that in a minute. But one thing that will be very difficult for me to do is to get an injunction that says that in the future, I am able to speak. Unless I could demonstrate that it's highly likely that same thing would happen to me again in the future, which is sometimes a really high barrier. In the case itself from the early 1980s, Los Angeles versus Lyons, it involved a man in Los Angeles who was placed in a chokehold. It was during a routine traffic stop, and he posed no threat to the officers, and he survived. But a number of people around the same time did not. So he was rendered unconscious. He lost control of his bodily functions while he was unconscious, and he sued both for damages, but he also wanted an injunction that said that it would be illegal to place people in chokeholds again unless they constituted some sort of threat to officers or to others. And the Supreme Court said the problem is, Mr. Lyons, you can't demonstrate that this is likely to happen to you again. You're only able to demonstrate that this happened to you before. And although you're able perhaps to demonstrate that this might happen to somebody in the future, you can't show that it's likely to happen specifically to you. You're just a law-abiding citizen who was stopped during a routine traffic stop. It's unlikely that you're going to experience this specific injury again in a city the size of Los Angeles. And so that's an example of why sometimes it might be difficult to actually get a federal court order that might kind of meaningfully shape the conduct of a local government or a state government in ways that can have a lasting effect. Because there has to be someone who, again, can show that they specifically are likely to experience an injury again in the future. Another place where standing doctrine comes into play, as of late, is that sometimes Congress actually will create a remedy that allows people to go into court when their rights have been violated. For example, there's a law that allows people to go into court when a credit reporting agency says false things about someone on their credit report. And it's intended to try to make sure that credit reporting agencies, that they engage in some degree of due diligence to make sure that, that when people are applying for credit, that the information that's being passed on about us, that it's actually true. In the most recent case, Transunion versus Ramirez, which was decided last term, there were a group of individuals who had false information on their credit reports. Specifically, they were accused of being terrorists, falsely. And they sued under this law that said if credit reporting agencies are not engaging in inadequate measures in order to make sure that the things that are on our credit reports are true, then you can sue, and you could get a set amount, $500 per violation. Now, on the other side of that, if every single person sued, even though $500 doesn't sound like a lot of money, if a lot of people are able to demonstrate these types of violations, it could have a really substantial effect on a credit reporting agency. The Supreme Court said that those individuals could not sue unless they could demonstrate that the information was actually passed on about them and affected them in some way. So the mere fact that their credit report said false things was not enough unless they could show that it had actually been passed on, even though this information was, it was something that no one would want said about them falsely. Probably no one would want said about them truthfully, but certainly no one would want said about them falsely. And that's an example where the court said these individuals have not experienced an injury. And that opinion has been widely criticized by academics. There was a sharply written dissent by Justice Clarence Thomas, a native Georgian, who strongly disagreed with that particular opinion. But that's one example of another way that kind of at this initial standing stage that is sometimes difficult for people to bring suit. Another barrier is what's called the political question doctrine. And the political question doctrine says that there's some circumstances in which federal courts shouldn't get involved because the underlying question is simply, as the name suggests, too political. So for example, if the court might in some instances believe that there's no manageable standards that they as a court could use in order to actually resolve a case. So one of the most recent examples of this came in the context of partisan gerrymandering, where the Supreme Court said that when it came to questions of political gerrymandering, they weren't really able to actually identify what standard they could use in order to decide what falls on what side of the line. The argument went that legislators have been partisan when it comes to redistricting since the beginning of the Republic, and there's really nothing textual in the Constitution that gives courts a strong indication with respect to what falls on what side of the line. The difficulty, though, is that, and this is my opinion, if the court stays out too frequently of ways in which democracy can be undermined, then it's hard to know who in our judicial system or who in our federal system has the incentive to actually check it. Politicians don't really have much incentive to check things like partisan gerrymandering, right? You know, this is online, but if I were a politician, I'm not sure that I would have the strongest incentives to check partisan gerrymandering. I'm just being honest. I would hope that I could be the person who says absolutely not. Please don't consider a political party when lines are being drawn. But it's almost hard to imagine that politician. And if that's true, right, then the question becomes who in our system will ensure that people are selecting the politicians who represent them rather than politicians selecting their voters. And so that's one point of view. In addition, another set of barriers comes around the remedies themselves. Right? So I've talked about standing and political question doctrine, which kind of come at an early stage, but there's also questions or moments in which the Supreme Court has constructed barriers to remedies like damages. The one you're almost certainly the most familiar with is the doctrine of qualified immunity. Maybe you hadn't heard of it 4 or 5 years ago, but most of you have probably at least heard the term at some point over the past 4 years. I'll give you an example of a recent case in which the doctrine of qualified immunity was used. It's a case out of California, in Sacramento. Police officers were executing a lawful warrant, and they, in the process, seized $250,000 from someone. And what they were supposed to do at that point is they were supposed to take it to it was supposed to be filed away in a formal way, but instead of doing that, they kept the money for themselves. They kept all $250,000 for themselves. Or, put differently, they stole it. right? They stole the money. Law sometimes has this way of, you find yourself saying things in the way that might not be the most direct, right? And in the most plain terms. But in the most plain terms, they stole the money. The person whose money was stolen sued. He said, this is a violation of my Fourth Amendment rights, and this is a violation of substantive due process. And the federal courts said, well, we're not sure, we're not going to say whether this was a violation. We don't need to say whether this was a violation of the Constitution because these officers were protected by qualified immunity. There's no case in this circuit that has said that if someone keeps money in this circumstance, that it violates the Fourth Amendment or that it violates substantive due process. They said the Fourth Amendment says that you can't engage in an unreasonable seizure. And these officers didn't engage in an unreasonable seizure. Remember, as I told you, they were executing a lawful warrant, right? And so they said the seizure itself was not unreasonable. It was the actions after the seizure that were unreasonable. And they said it wasn't clear under the law of that circuit that keeping the money constituted an unreasonable seizure. They also said that it wasn't clear that it violated substantive due process either, because there weren't enough cases that were specifically about stealing in that particular circuit. And that's the Ninth Circuit, which is the circuit that grants qualified immunity among the least, right? So that's one reason why I often cite to that particular case, because if that's what's happening there, I could give you other examples from right here in the state of Georgia that you might also be equally surprised by in terms of the result. In addition, there's prosecutors who actually get absolute immunity, right? So qualified immunity means that the plaintiff needs to show that, that an officer or any other government official violated a clearly established right that a reasonable person would have known at the time of the violation when they're seeking damages. Prosecutors get absolute immunity. So for example, if a police officer, if a prosecutor trained witnesses to lie and put them on the stand in their cases like this, you can't actually sue that prosecutor for damages because those acts took place pursuant to the prosecutor's prosecutorial capacity, right, and their adversarial role. Now, if a prosecutor does something during the course of an investigation, you may be able to sue them for that. But if it's connected to their actual adversarial role, like putting someone on the stand, then those prosecutors are entitled to absolute immunity when it comes to damages. I'm among scholars who have written that it's time to revisit some of this, right? Now, as I noted, there are reasons why the court has constructed these doctrines. And in every example I just gave, these are judicially, the Supreme Court constructed these doctrines. These are not doctrines that came from Congress. These are not doctrines that came even from state legislatures, at least not initially. These are doctrines that federal courts have themselves created in order to protect federalism, in order to protect separation of powers, and in order to protect judicial economy. And therefore, I'm not really necessarily convinced that the solutions are going to come from courts, but instead, solutions I think are going to have to come through democratic channels, small d, Republican channels, small r. Right? They're going to come from us as voters, demanding more in the way of accountability in ways that are reasonable, right? And looking for, as Speaker Murphy did for so many years, looking for a middle way, because in my view, we've just gone too far when it comes to creating barriers to constitutional accountability. And we need to be looking for solutions that can balance the need to protect values like federalism and separation of powers with the need to hold the government accountable when the government violates the most important charter in the land, the United States Constitution. Thank you.
What questions do you have?
Yes.
Recently, the Alabama State Supreme Court said the new
redistricting map for, I want to say, their congressional districts was unconstitutional. But then the Supreme Court just, I want to say, recently reversed that holding, making it, I want to say, the districts constitutional, allowing there to just be one Democratic district while the rest are Republican. So why didn't the Supreme Court use the political question doctrine then recently? Like you said, it has in the past.
Yeah, so if the question in that case had been, are these maps too partisan? Then the answer in a federal court, at least at this point, has to be, that's a political question, no involvement. Now, there's other ways in which federal courts can get involved in redistricting. So going back to the early 1960s under a case called Reynolds versus Sims, there's a one person, one vote principle. And that still is enforceable. So if a map is drawn and there's 200,000 people in one district and 40,000 people in the next door district, that's unconstitutional under the Equal Protection Clause, and that's actually enforceable. Another limitation under the 14th Amendment Equal Protection Clause is racial gerrymandering. So legislators are not allowed to predominantly, at least, consider race when they are drawing lines. And what's also true is that there are limitations that come from the Voting Rights Act. And there's a big question mark right now about what this current court thinks of what the right limitation should be when it comes to interpreting the Voting Rights Act. The case that you're referencing is a Voting Rights Act case. Under Section 2 of the Voting Rights Act, one of the things that legislators are not allowed to do is dilute a racial group's ability to participate in the political process. And that's been true since the mid-1960s. And there's other parts of the Voting Rights Act that the court has already invalidated. So there used to be a provision called preclearance, where in states that had a history of racial discrimination in the context of voting, they would turn their any major changes to voting over to the Department of Justice, and the Department of Justice would have to pre-clear it, right? Or determine whether or not it was, in the words of the Department of Justice, retrogressive. That is setting us back when it comes to questions of participation in the political process. That provision no longer exists, right? So that provision was overturned in 2013 in a case called Shelby County versus Holder. And the court, and even though that provision, I should say, it passed with 98 votes in the United States Senate, which is really kind of it feels like a stunning number today. But in 2006, the most recent version was signed by President George W. Bush, 98 votes. The version before that overwhelmingly passed, signed by President Reagan. The version before that overwhelmingly passed, signed by President Nixon. The version before that overwhelmingly passed, signed by President Johnson. But the Supreme Court determined that, in the words of the Chief Justice, quote, things had changed in the South, and that this particular provision could no longer be justified by current conditions or needs. And so that provision was ruled unconstitutional back in 2013. Long answer to your question. But the reason I'm bringing it up is because the case you're referencing is about the Voting Rights Act, and it's about a part of the Voting Rights Act that still remains in effect, Section 2, which again is about vote dilution. In that case, the federal district court 3-judge panel determined that that the state of Alabama had engaged in voter dilution with respect to African Americans' ability to participate in the political process. They held a 7-day trial, and those were their findings. And what happened in the case that you're referencing is that the Supreme Court stayed that decision, meaning that injunction that the federal district court put into effect is no more, right? The lines that Alabama drew may continue. The Supreme Court did not say that the lines were legal, to be clear. What they said was that, under a case called Purcell, that federal courts shouldn't interfere with elections too close to an election. And what some scholars have noted is that principle originally came in a case where a federal court intervened in October with respect to a November election. And that line seems to be, at the Supreme Court, seems to be moving earlier and earlier and earlier. It's February, it's early February. And the primary is 4 months away. And the general election, of course, is in November. But that's the principle that the Supreme Court invoked over 2 dissents, one of which was by Chief Justice Roberts. Chief Justice Roberts wrote Shelby County versus Holder. He wrote the opinion that overturned the preclearance provision of the Voting Rights Act, and he dissented, which does certainly tell us something, I think, about where the court might be headed with respect even to Section 2 of the Voting Rights Act. It may be seeing its final days in ways of enforcement that has any real teeth. Any other questions? I promise I'll give a shorter answer next time.
In regards to seizures by law enforcement, are those assets just kind of supposed to be just stored away for a little bit until the investigation can clear things up, and then if everything checks out, are they supposed to get that money back?
That's correct.
Okay. In the case that you mentioned, if the investigation showed that they've done nothing wrong, how would they go about getting their money back?
Yeah, it's a fair question. I mean, I would maybe recommend that they at least try. I mean, so suing the individual officers is off the table, right? Can't do that because of that case. I would recommend that they might consider trying a takings claim because they were government officials. They were acting on behalf of the government, at least at the time that they seized the money. And to the extent that that this is taking possession of someone's property, under the Fifth Amendment, one is supposed to get just compensation. So that might be one avenue that they could at least try. I don't know if it would work, but that's all that immediately comes to mind. But it is the case that sometimes there's violations where there's not going to be a remedy. Yes.
So come up, why could they not be criminally charged?
Now that they could.
Paying the money.
Yes, so criminal charges sometimes can still be available. So qualified immunity, and it's a really good point. Qualified immunity does not obstruct the ability to hold someone criminally liable for violating criminal law. So really good question. What qualified immunity does is it prevents the plaintiff from obtaining money damages. But criminal liability would still be an option. Great question. And I should look to make sure that, I suspect they were held criminally liable. And I should look to make sure that that's so.
I know, because it's like, who's watching the hen house?
Right.
There's and stuff that's supposed to go to rectify the wrongs that were done to gain the money.
Absolutely. I mean, that case really, it baffles me. I mean, it's almost like I think, I'm like, was the Ninth Circuit trying to set up the Supreme Court? Like, so were they saying, look at how awful this doctrine has come, and with the hope that the Supreme Court would intervene, but the Supreme Court didn't intervene, and so now it's just the law.
In my experience, the reality is the scales of justice are supposed to be balanced. Everything's fair, but it's not the real world
Yeah.
this day, and it's really a sad thing.
Yeah.
Especially for those of us that know. Right.
Yeah. No, absolutely.
So, yeah.
And I think we have to depend in some ways on our elected officials more than courts. I'm increasingly persuaded to kind of get it right and to guide or limit judicial discretion in these kinds of cases. Because I feel confident that most people think that in a case like what I just described, that you should be able to sue for damages, right? And so this is the pendulum has swung, right? In terms of the scales of justice analogy.
I just can't imagine the changes I've seen at 72, what they're going to see. And it frightens me for them. And I would say, to be honest with you, so be active in court.
Absolutely.
Be counted.
We have to. Absolutely. Thank you for that.
Is the problem with that particular case, that they sued the wrong people, they couldn't have sued the cop, the police officer. But somehow or another, they needed to force the government to enforce the law over the police officers to make sure that the money was returned in some particular way. It seems to me more a case of the wrong person got sued.
Yeah, well, what's interesting is that the name of the case is actually at the Ninth Circuit, it's Jessup versus City of Sacramento, because they did also attempt to sue Sacramento. But that creates another problem, actually, that I didn't even tell you all about. So under a case called Monell, which was a case decided in the late 1970s, you can't sue a city for a constitutional violation simply on the theory that someone who worked for the government or someone who worked for the city violated the law. You have to show that an actual city policy caused the violation in order to sue a city. And so that part of the suit was also dismissed for different reasons. Yes.
You said you hope for more, I want to say, accountability being put into practice by the legislatures. I've done research of where I looked at countries who've gone through democratic erosion, of where they put so-called ethics committees on justices, supposed to, I want to say, put some, what's the word, accountability to their actions. But sometimes those committees just get polarized and end up kicking out one side while putting in for judges. So what's, I want to say, your idea of having like an ethics committee or a behavior?
Yeah, so I'm not an ethics expert, or there's people who study ethics and professional responsibility for a living, and I don't want to encroach too much on their territory. But there does seem to be growing consensus among that group that a code of ethics at the Supreme Court level would be a good thing. Right now, there's already a code of ethics for all other federal judges, and I don't think that the allegation is that the Supreme Court is engaging in unethical conduct, but just that it would give people more confidence if they were bound by the same rules as other judges. And that, at least based on, I mean, again, this isn't something that I directly study, but that seems reasonable to me. But you also, but I'm talking more about actually the creation of remedies by legislators. I'll give you an example. A few years ago, the Georgia Supreme Court, which, by the way, is full of members that I deeply, deeply respect. Right? I'm teaching a class with Chief Justice Namias next year. We're co-teaching a class on state constitutional law. In an opinion about whether or not you could sue government officials for injunctions or for what's called declaratory relief, where a state court would say, you declare that a set of actions are violating someone's state constitutional rights. This isn't about the federal constitution, it's about the state constitution. The state Supreme Court said that those individuals are also entitled to are entitled to sovereign immunity. So anytime you sue, the theory went, anytime you sued a state official for an injunction or for a declaration, if you were suing them in their official capacity for one of those things, then you couldn't do it because of sovereign immunity. And there were a lot of people who thought, whoa, that's really extreme. Surely you should at least be able to get an injunction under some circumstances. And the state legislature almost immediately, within 2 to 3 years, they responded. And I know, when you vote, and sometimes there's these things at the end of the ballot where it's like, can the state of Georgia do blah, 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 and you're like, oh wait, I forgot to study for this part. I knew who I was going to vote for. I wasn't ready for this part of the test, basically. And even I have felt that, and I try. I think we all try to pay attention. But one of the most recent referenda last year was one where voters were asked, can people sue for injunctions? Can you sue government officials for injunctions and declaratory relief? And the voters said you can. So the state constitution was amended to allow that, which I suspect is what the Supreme Court actually wanted, right? They didn't think that the Constitution as it was written, the state constitution allowed for it. And the legislative process, there was a response, right? And that's what I'm inviting more of, that kind of dialogue. I think we've gotten a little too used to just assuming courts will figure it out.
Well, I'll just, I guess, close with, when do you see the rest of this term, the Supreme Court term, as well as in the future, where do you see the court going?
On what issue?
Well, big topic. So you've got the abortion case right now. You're going to have affirmative action coming up.
Yeah, you caught me in a mood where I'm willing to predict. I don't know why. I usually don't. Yeah. So on each of those. So yeah. So I think that the court will likely conclude that it remains true that women have some degree of choice when it comes to the decision about whether to carry a child. But I think that they'll say that 15 weeks is long enough of a time period to make that choice. Now, don't shoot the messenger. I'm just telling you it's just a prediction. That's what I suspect the court will say. And that's what the chief was really advocating for. Now, that said, it's not the chief's court, as the case we just talked about demonstrates. There has to be someone else who's willing to say that too. But I think when you put pen to paper, yeah, I suspect I suspect that's the easiest opinion to write. And so a law like the current Georgia law, which is a 6-week law, would still be unconstitutional under that line. But the Mississippi law, which is a 15-week law, would remain in effect under that line. So that's what I could be. I'm not there. If I were there, I couldn't tell you, right? Like if I knew, right? Those who know don't say, and those who say don't know. So it's just a prediction. On the question of affirmative action, it's a goner. And already has been in lots of places. I came here from Berkeley, where affirmative action, voters got rid of affirmative action back in 1996. I don't think that racial considerations are present in Georgia's public admissions, and I don't think they have been since the 90s either. But there are, but I think that both under the 14th Amendment and under Title VI, I think the Supreme Court will say that essentially almost any consideration of race in the admissions process is illegal. And again, this isn't me saying what I want to happen. This is just literally me describing what I best predict will happen.
Well, if there are no more questions, thank you so much for coming tonight. Thank you all for coming. The next Murphy lecture will be March 1st, so hopefully we'll see much of you there. So thank you. Good night.
It was wonderful. Thank you.
Thank you.
Thank you for doing that.
Absolutely, my pleasure. Thank you.